materials, the investigative genetic genealogy materials that the defense wants and believes that to some extent is exculpatory.
They've been jumping up and down about genetic genealogy. They appear to have some suspicion that the feds crossed some unlawful lines.
It seems like they think there is more to this IgG DNA evidence than meets the eye.
And the belief may be that the feds somehow got to that name, got from the touch DNA to the name of the father by doing something they shouldn't have.
Part of what's making this case so unusual and how they found him. Remember, they found what they believed to be his DNA on the knife sheath that was found next to one of the victims, but they never actually found the murder weapon, the knife.
Certain information contained in the IgG saying they got it a different way, all just to find how and when Mr. Kohberger was identified as a suspect.
And so they used public genealogy databases, which is what's so controversial here. And the law is sort of untested in this area, and it's part of what he's using to challenge the evidence and try to get it thrown out.
If Kohberger is identified through this process of IgG, then that is fruit of the DNA tree, and he is entitled to know the investigative technique and the science behind this and what was done.
Is the state scared of the defense finding out how and when Kohberger was identified as a suspect? I don't know.
That they knew Bryan Kohberger was their suspect, and they knew it well before they now say they knew it, which was the end of December. Now they want us to believe they didn't have him until the end of December.
That you can't keep an investigative technique secret. The defendant has a right to know how he was investigated, starting with how he was identified.
What the defense believes it might have grounds to blow up this entire case because everything thereafter, the cheek swab that actually did show it was Bryan's DNA, is fruit of the poisonous tree.